Well, good morning and welcome to today's webinar, Understanding Estate and Trust Administration, presented by Elville and Associates Managing Principal and Lead Attorney Stephen Elville. My name is Jeff Stauffer, Community Relations Director with Elville and Associates, and I'll be moderating today's event. So how this will work today, if you're new to our webinars, if you are, welcome. We're glad you're here, and if you're returning, welcome back. You as the attendee are in listen-only mode. However, if and when you have questions, please note them in the right-hand portion of your screen in the questions panel, and we'll take time throughout to address them. Your questions really help the presentation. They help others learn, so please don't be shy in posing your questions at any time. You received the presentation and handouts Steve will be referencing yesterday by email from me to take notes on them if you wish. If for some reason you did not receive the presentation and handouts, they are available in the section marked handouts in the panel on your screen to download at this time. For CFPs, CPAs, and various other professionals on today's webinar, you may receive 1.5 continuing education hours for attending. So per my attendance records requirements, please email me your board ID. And for CFPs only, I also must have the last 4 digits of your social security number as soon as possible so I can submit your CE hours for approval. Everyone will also receive a post-webinar feedback email right after the presentation. And as always, we ask that you please just take a couple minutes to fill out this simple survey to give us your feedback about the presentation. We read every comment and value your feedback very much. It's also an ideal time to request a consultation with Steve for planning needs that your family and you may have now or in the future. And we always look forward to being a resource to you here at Elville and Associates. So briefly, I'd like to give you an overview about our firm and share a bit about Steve. So you should be able to see my screen now. So Elville and Associates, we were founded in 2010 by Managing Principal and Lead Attorney Steve Elville. We have a number of different practice areas here at the firm, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, and tax planning and asset protection. We have 7 attorneys, 12 staff members, and 5 locations, and Steve and I are coming to you live from the Columbia Gateway location here in the heart of Columbia. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. We do offer a lot of education here at Elville and Associates, which is one of the foundations of our firm. We do that in a number of ways. Through our planning processes with our clients, we offer about 100 educational webinars and workshops in the communities we serve each year, and also by way of our accredited client care program, or CCP as we call it. We are one of only 2 firms in Maryland to have an accredited CCP by the Client Care Academy in Boston. We also work with the ideals of client education, collaboration, and compassion with every client every time here at Elville and Associates. A little bit about Steve. His work as an attorney the past 20+ years has been centered in elder law, special needs planning, and estate planning with an emphasis in the areas of tax planning and asset protection. A member of many different national organizations, including the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys. He works to bring peace of mind to clients by creating solutions to their needs through counseling, client education, and the use of leading-edge legal technical knowledge. Also, last year's chair of the Elder Law and Disability Rights Section Council of the Maryland Bar Association, a very seasoned speaker. If you haven't heard him speak before, presenting at many webinars, workshops for businesses and their employees, conferences, and other events throughout the year. Also named to the Maryland Super Lawyers list for a 6th time in 2021 and a 5th consecutive year, so congratulations to Steve. And also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charitable organization he founded in 2014, and I am privileged to be the executive director of. We work with many school music programs and other organizations throughout Central Maryland and beyond to help give the gift of music to children that want to participate in music but may not have the means to do so on their own. So we work very hard every day to make a difference in the lives of those kids and their programs. So if you'd like to learn more about that, please feel free to reach out to me and I'd be happy to share our story about the Elville Center for the Creative Arts. So with all that being said, we're gonna get into the presentation here. We're gonna start off with a real brief poll just to get an idea of what's brought you here today. And the poll is, as I go ahead and launch it, what has your experience been with estate and trust administration to date? So you should see that box pop up and you can, well, if I can get it to pop up, let's try that again. There we go. Choose the option that best fits your situation. The choices are, I have been the executor of an estate in the past on my own. Secondly, as an executor, I sought professional guidance throughout. Third, I may be asked to be the executor of an estate in the future. Fourth, I want to keep my planning in order to keep costs down. And lastly, I'm an advisor here to learn to better serve my clients. So welcome to everybody. If you could just choose what best suits your situation or maybe future situation. And we'll give it about another 10 seconds or so. Okay, it looks like everybody who's decided to participate has done so. So we have 12% saying, I have been the executor of an estate in the past on my own. 6% having said, as an executor, I sought professional guidance throughout. 29% say, I may be asked to be an executor of an estate in the future. 35% say, I want to keep my planning in order to keep costs down. And lastly, I'm an advisor here. 18% say I'm an advisor here to learn to better serve my clients. So welcome to everybody. Steve, I'm going to go ahead and click that button that's going to make you the presenter. You should see that pop up.
Excellent. All right, Jeff.
See your screen?
I'm presenter now. Can you see that?
Yes,
very well?
I can.
And I'm going to start my slideshow. And thank you, Jeff. Good morning, everyone.
Thank you.
Thank you, Jeff. And good morning. And it's my privilege to be with you again today on this Friday morning. Thank you for spending your Friday morning valuable time with us. And it's a beautiful day outside. I hope it is where you are. It is here in Columbia. And I hope you have a great day ahead and a wonderful weekend ahead. This webinar is at the core of what we do. It's part of the process of not only designing an estate plan, maintaining an estate plan, but also executing on the estate plan at the time of our death or the fruition of the estate plan. So this one is very, very important to our and near and dear to our hearts. It's also very important to you. And I know many of you on this call this morning, this webinar this morning, are looking to, get into the frame of mind as what are the best practices in estate and trust administration. Some of you, I heard loud and clearly, have already done this before. Many of you are anticipating doing this. Many of you are just estate planning clients who want to know what are the best practices. So we're here to get into all that this morning. I want you to know that Jeff is an expert moderator. He is my longtime friend and colleague here at Elville and Associates. He is dedicated to taking your questions as we go through the workshop. I will do my best, even though we have a lot to cover today, I will do my best to stop at various points in the workshop to allow you to ask questions. And we will also see those questions occasionally as they pop up. So just know that it's our intention to answer, I should say, all the questions that we possibly can. However, because we have so much to cover, I just want you to know that this is kind of like climbing Mount Everest, or at least planning to climb Mount Everest. It would be hard to plan to climb that mountain in an hour and a half, which is about what we have here, a little bit less than an hour and a half. So just know this is a compilation of my experience. It's designed to give you, a tool that you can work with, just like all of our webinars, so that you can walk away with something tangible that you can use in your thought process and in the actual process of estate and trust administration. But it's also designed to go back to what I said, best practices. It's designed to give you a frame of reference And best practices is a term often used in professional world, in the CPA world, in the attorney world. Best practices is, what we all know we should be doing as best practices. And if you as a layperson, if you are a layperson, if you can kind of extrapolate from that, if I can look at those best practices that the professionals are looking at, and then even approximate to get close to that, then I'm doing very, very well. The other thing that I want you to know is that there's a lot of responsibility and liability in being a trustee or a personal representative, and most of you know that. So also what I'm trying to do here in this presentation is make sure that you have a frame of reference about the liability, the structure, the process, and so forth. So one of the greatest gifts I could give you as we move forward in this presentation, as you see in your materials, there are checklists. And I've tried to give you a step-by-step checklist, what we call the critical dates checklist, one for estate administration and one for trust administration. And what you're going to see when you look at these checklists is that in many respects, they are similar. And in some respects, they're not the same. But what I want you to understand is that administration is a process. And if we're thinking about minimizing our liability, having highest and best practices, we want to be driven by a process. And of course we do. The other thing as we get ready to get into the slides, and again, you should have this as a tool, I think that the best approach that we should take today is I'm going to give you what I think is the legal perspective. We're going to start with the legal perspective. I'm going to give you some illustrations and some examples. We're going to work through those examples. And basically, I'm going to say that that's step one. Our first phase of the presentation, which is going to be the biggest phase, is working through the legal aspects. And then as we close in the presentation, I'm going to shift to the practical aspects. So we're going to talk about both the legal and the practical. But again, I don't want to minimize the fact that this checklist and any checklist that you can get from a credible source, and also any checklist that you might get from the Register of Wills if you were actually administering an estate in Maryland or any other state, that checklist is golden, and that is what should drive your process. All right, so with that said, let's get right into the material, and thank you again for being here today. So what we're going to do is really look at an unraveling a mystery of what happens after someone's death. One of the biggest questions that we see in estate planning is when clients are in the process of planning is sometimes they will say, I'm completely mystified about what happens to my trust, for example, upon my death. That is one of the most common but yet simple questions that is ever asked in estate planning. So we can't minimize the fact that most people just really have no concept of what happens. And of course, what we're going to see is what happens in the case of a trust is that the living trust that was revocable in that example becomes an irrevocable trust. If we're talking about a straightforward revocable trust, now we have an irrevocable trust that has to be administered. But that particular question is what mystifies many people. We want to minimize confusion and we want to provide support. If you're an advisor on this particular webinar, we want to provide support to clients. If you're a layperson and you're not a professional on this webinar, we want to provide, of course, support to family members at a time of crisis. And we're going to talk about the legal step-by-step process that I promised we would. And then we're going to talk about the practical steps after death. But we're also going to examine the most significant of these legal and tax issues that advisors and lay people and trustees, meaning fiduciaries, because you're in a fiduciary role, that you should be aware of. And then we should talk about how, not only from the perspective of the professionals, how personal representatives and trustees and financial advisors and CPAs should all work together, but from the professional side. We, as the folks on the professional side of the fence, we need to understand how to work together as well so that there is communication, intentionality, and all of those important things that are so hard to achieve in reality. These are things that are easy to talk about, but very hard to achieve in reality. So what happens after the death of a loved one? As I mentioned earlier, this is one of a client's greatest concerns. If you're a layperson and talking about your own plan, I know you're concerned about this. If you're a potential trustee of someone else's plan, I know you're concerned about this, and this is what you need to understand. This is really where the concern is. Who will be there to support me and so forth? We have wills, which are subject to probate. What is probate if you're not familiar with it? Probate is the process of proving a will to be valid, or if there's no will, probate is the process of basically administering an estate where there are probate assets that are going to be distributed according to the laws of intestacy, the laws of intestate succession, which are different in every state. And remember, what is a probate asset? A probate asset, and I'll repeat this if you need me to down through the rest of this presentation, a probate asset is an asset that is not jointly owned, and has no beneficiary. That asset is going to go through probate. And remember that probate is different in various states. Our neighbors in Virginia tell me that probate is relatively easy in Virginia, and versus Maryland or New York, I understand that, of course, in that state, New York, probate is very robust, just like it is in Maryland. We have a very robust process of probate. Trust administration has to do with the living trust, in the example of a revocable trust, becoming an administrative trust that has to be administered at the time of death. If we already have other irrevocable trusts, whether it's a life insurance trust, which we won't get into today on these more advanced issues, we're going to keep it more basic, a charitable trust, any other kind of irrevocable gifting trust of any kind, a residence trust, those trusts have to be administered in different ways. But basically, after the death of the grantor or whenever the triggering event is, that trust has to be administered and distributed. And then there's a transitionary period. If we go back to this checklist, you're going to see that the Register of Wills process typically is around 9 months if we look at the length of probate. But if we look at non-probate, which is the administration of a trust, then we're still looking at several months. Now, there are various exceptions to this. Sometimes there's a very simple administration. If there's only a surviving parent and a surviving only child, the situation could be very straightforward. But if we have 3 or 4 or more siblings and someone has died and someone is administering that trust, then we're going to have to go walking through a series of steps to be accountable and making sure that everything is accounted for. So every situation is different, and that's why this is just a general summary this morning of best practices, but this is the framework that we're working from. Who will be there for the surviving spouse and children? We talked about that. Supporting family members. What should they do? What should they anticipate doing? I know a certain financial advisor who is a great friend of Elville and Associates, and this person has always challenged us to think in terms of not just educating clients, but organizing clients. So part of the organizing process would be, and to your credit, if you're on this webinar this morning, you are thinking about that. Part of the organizational process is really getting ready to it in advance. What should I do? What should I advise others to do to be ready for this event? And as I mentioned, we should be always driven by a process. We should always be driven by best practices. We're going to talk about that. Not circumstances. We don't want to be driven by circumstances, although sometimes that's unavoidable. If someone dies with no will, if someone dies with assets they're not aware of at the time of their death, and they have to, or they're not exactly organized, and the executor has to find those assets. But we want to be driven by a process. And to whatever extent you are on this webinar this morning and you're thinking about your own personal process, and you say, what can I do to make things as easy as possible for my successors, my executors, my trustees? It's really making sure that everything is fully funded, everything is fully aligned in your own estate plan, your retirement assets, your non-retirement assets, making sure that we have checklists of and spreadsheets of assets, making sure that digital assets are available to the executors. This is not always easy to do. It's not always the right thing to do in all circumstances, but that is a best practice. And then again, that's exactly what I'm getting at here in the last bullet point: preparation through planning, education, and organization. Now, I'm going to go through 4 examples this morning, And they're not perfect examples, but I tried to take a slice of life, so to speak, from the various situations that we see and try to illustrate, which is with as much power and clarity as possible, the different kind of situations that you could encounter, just as a very brief workshop tool this morning. We're going to look at 4 case examples. And I find, and there probably are exceptions to this, I find that there are basically 4 different kinds of estates or plans that we see. We see estates and trusts where the plan is very clear, and that's what we want. We want that very clear plan. The structure is clear. There may even be a diagram that's included in the estate planning documents. The executor or trustee is very clear about how everything works. It's a trusted person who is a very much together person. Everything is clear. Then there are trusts or estates where they are asset specific. There are varied types of assets, but let's say there's a lot of retirement type assets, or other assets have been strategically placed, either because the client was advised by various advisory team members to title things in a certain way, and they are driven in a certain direction. Those types of estates or trusts that are more complex as far as the assets go, that is something that needs clarification as well on a very clear estate planning spreadsheet. So for example, my personal executive assistant, Mary Gay Kramer, who is well known in Maryland as a paralegal, she creates a spreadsheet that is very specific about what are the assets, how are they currently titled, and this is in an estate planning situation, where are the assets supposed to be going, or how are they supposed to be titled, and a confirmation of those assets. So many of you who know Mary know that she is very good at this and tracks these things down relentlessly, because she understands that this is what makes an estate plan work. So we could be looking at a trust or an estate administration where there are very much asset specific things that need to happen upon the passing of someone, and we need to be able to reference these things clearly in a perfect world. Maybe there is a need-specific situation. There's a survivor of whether it's a child, whether it's a spouse, whether it's a domestic partner, and a situation is different than it was anticipated. Maybe someone is ill. Maybe the person who died never kept up their estate planning and never did the updating and the maintenance and so forth that they should have done, and therefore the plan is not really in tune with the needs of the survivor, whoever that may be. Or we may have a fact-specific plan that just talks about literally nothing that should happen. There's no plan, or it's a very poor plan. And the fiduciary, the trustee or the trust protector, in this example, the special fiduciary that is in many documents today, maybe they have to make judgment calls. So these are the 4 examples. And I'm just going to very briefly go over each one of these examples. I promise that I'm going to come back, because in prior trust and administration workshops that we've done, both before COVID and after COVID, we know that this is where most people's interest is. They want to see these examples. They want to hear me go through them. So I promise we will go through them. I'm going to show you these examples, move through the legal considerations, and then I promise I'm going to come back to the examples. So the one that I've chosen here this morning, the first one, this is the death of a single person who was never married. Single person who was never married. This person was an older man who was 77 years old with 1 son. So this is a single person with 1 son. He has a residence, he has checking and savings, he has an IRA, and he has savings bonds. So if we were to look at this person's estate, this person did have a will, if you look at the bottom bullet point, and he's leaving everything to his son, Charles, outright. So this is a very straightforward disposition, but everything's fairly clear. He has made no lifetime gifts, and he has income of $2,300 from Social Security at the time of his death. So this is a single person with a will. So that's example number 1 that we're going to go through. I promise we're going to compare these examples to the checklists as much as possible to give you a frame of reference and something practical that you can take away from today's workshop. The second example now, I'm moving to a married couple. This married couple has a revocable living trust. And if we look down at the bottom of this slide, we see that the revocable trust is going outright to the surviving spouse. This trust is pretty simple. And many of you who are familiar with wills and trusts understand what I'm saying here. This trust, it distributes outright at the death of the first spouse, and it goes to the survivor. In this case, her name is Janet. And this person, Jack, who was the deceased spouse, the husband, he died, unfortunately, only at age 69. He had 3 children and a surviving spouse. So this is a revocable trust plan with outright distribution to a surviving spouse with 3 children in addition. Now, those of you who are very educated on this call, and I get the feeling we have a lot of more educated people on this call as far as estate planning goes. I'm just going to make sure you understand, however, a revocable trust is a substitute for a will. So in the first example, we had a man who had a will. We're going to talk about his situation, but this example, we have a revocable living trust. So this couple would have either 2 separate trusts, or they would have 1 joint family trust. I get the feeling from this example, they've been married for a long time, so they probably have a traditional situation. Maybe they have a joint trust. Either way, this trust leaves everything to the surviving spouse. But what do we know about revocable living trusts? To make them work the way they're supposed to, they have to be funded and aligned. We talked about that. So there has to be a design of the trust. And so obviously this person did that and they signed their trust. And now we are making a lot of assumptions here in this example. We're making the assumption that they fully funded, and for those of you who get concerned or confused by that, they fully aligned their assets with their revocable trust. So the assets here are a residence, CDs, and I'm just going to skip down to the brokerage account, and the Delaware residence. What do we know about those things? Those things are non-retirement assets, and those should be, and as far as this example goes, they are in the trust. So these assets are funded into the trust the way they're supposed to be for purposes of our illustration. But what do we know about the 401ks and IRAs? Well, we know those cannot be titled in the name of a trust. So those are outside of the trust, and those are going to be beneficiary driven, beneficiary designated. So let's just make the assumption here that these IRAs are beneficiary driven to the survivor, who is Janet. In other words, Jack's $900,000 is beneficiary driven to Janet, and also that the life insurance is also either beneficiary driven to Janet, or in some cases, the life insurance is beneficiary driven straight to the revocable trust. But I just want you to make this assumption that not only is this a married couple, one of them has died, there is a revocable trust, but I want you to make the assumption that everything is aligned as far as the assets go inside the trust and outside the trust. Now, this is our hypothetical fact pattern 3, and this one is the same couple, just for purposes of our discussion, but Janet now has survived for 20 more years after Jack's death. She's now, I guess, according to our prior example, she must be in her 80s or late 80s, and now she has died. So we are now looking at her trust estate, so to speak, and she has a little bit of a different asset situation, sometimes a little bit similar, but in other ways different than it was 20 years ago when Jack was still living. So here we have an estate plan. It's really Janet's revocable trust now that it's being administered, and it's being distributed to the children equally. So I wanted you to see our first pattern is a single person. The second pattern, and that single person, by the way, has a will. The second pattern is a revocable trust for a married couple where the first spouse dies. The third pattern is a revocable trust where both spouses have now died, that same couple, and the various things that are important to think about. And the fourth one, as we mentioned in the different types of examples that we could think of, this is a person who has died, and this person is married. This particular person's name is Ricardo in my example, and his spouse lives in another state, and he has 2 children, and he had no estate plan. This person died without a will, and there are other circumstances. So we're going to talk about the will situation, the revocable trust situation, and then someone who dies without an estate plan. And notice in this particular estate, this client has some cash, he has an inherited IRA, he has some life insurance, but look what happened here, no beneficiary. He has made some lifetime gifts. So this is a person that did well at one time in their life and gave away a lot of money for whatever reason. And so we're going to talk about that, but he has no will and no estate plan at all. Jeff, I'm going to take a break now. We've been going for about 20 minutes or more. I'd like to see if there's any questions from anyone before I continue.
Thanks, Steve. No questions as of yet.
All right. Well, I know people are getting their second and third cups of coffee or tea or energy drinks these days. All right, so we'll keep going. So what we want to do in administration, which remember, in our opinion here at Elville and Associates, is part of the planning process. We don't want a transactional planning process. We want a caring process. We want a multi-step process, which really it's part of its design and implementation of the estate plan, maintenance and updating of the estate plan, and then final administration. So this is really part of the planning process, really. We want to minimize confusion and provide support at a time of crisis. So whether we are professionals or lay people, we want to have empathy for our loved one's situation or the person that we are trying to help in a fiduciary capacity. We want to assess the kind of support this person needs. This is a very, very difficult time. People cannot help themselves many times. And many times clients or people that are in this situation, having lost a loved one, many times they are stronger than others at times, and many times they overestimate their ability to deal with a situation like this. The professionals on the line, we really ought to have our entire firms involved in this understanding of the sensitivity of the situations that we're dealing with. We need to be creative. We need to have resources that are available to us so that we can easily be able to refer and basically be able to act as a coordinator. And many of you do that very well. If you are a layperson or a person who's going to act as a fiduciary for another, I strongly recommend that you avail yourself of certain resources that we can certainly talk about offline. So we want to assure that the client or the fiduciary that's involved or the persons that we're taking care of, that they take care of themselves first. What we see on the legal side of things here in the law firm is we see many surviving spouses or surviving relatives or surviving domestic partners in a state of shock, trying to move forward. And of course, you've seen that as well. It's a very sad situation in life that we deal with. We want to make sure that they are moving forward in a methodical way, but that they are not overly in a hurry to get things taken care of, like some of you have seen, and we have seen so many times, that probably isn't very healthy for them or healthy for the process. We want to assure them that all advisors are notified and are working together. This is, again, very difficult to do. So we want to make sure that our staff, our resources that are working together, that they're all coordinated. And this, again, is a question that I think the advisors on the call and the professionals need to always be thinking about as we train our teams and as we work together. We want to assure the client that everything is in order. And of course, if it isn't, we need to be very clear about what is not in order and have action steps. So let me just stop for a second and just say that there are certain steps that after a person passes away, and those that are in a position of being a fiduciary, and those who want to try to attain the level of best practices, there are just a lot of things that should be done up front. Of course, what are the fees involved? How many EIN numbers, the tax ID numbers, are we going to have? How are the advisors compensated? How is the trustee or personal representative compensated? What are the allowable fees? I know I'm talking a lot about fees here, but this is one of the big sources of confusion. Will the fiduciary be able to be compensated, and when? All of these things about obtaining date of death values and things that we're going to talk about, notifying creditors, even with revocable trusts, making sure that we understand the names and addresses of all the beneficiaries and getting that information as soon as possible up front, which goes back to the issue of organization. All of these things make things easier in the long run if they're done up front, and that's not an exclusive list. We want to assure the client that funds are available, and hopefully in the planning process, make sure that funds are available. We want to determine what final arrangements have been made, if any. We want to address family-related issues, and of course, being sympathetic and empathetic with the family as they are dealing with the time of tragedy and loss, about final arrangements and so forth, including the special arrangements that many veterans have. So what is the legal step-by-step process? So we have probate versus non-probate, wills versus trusts, wills and what happens in the probate process by definition, or if there's no will, but we have probate assets, how those assets will go through probate versus the non-probate process. And if we have a properly designed revocable trust, or if we are dealing with transferable on death assets, payable on death assets, exclusively beneficiary designated assets, how do we deal with those things? How do we make death claims? How do we make sure that we are meeting the critical dates that we're going to have to meet? So you're going to see as we go through this, there are similar steps, but different processes. I would strongly encourage those of you who are not familiar with trust administration to kind of accept the fact on faith that a trust administration has very similar steps, that you're going to want to walk through similar steps as you would have walked through with probate, similar but different steps, because in the exercise of your fiduciary duty, you want to be able to be totally accountable, totally transparent, and totally within the rules. Sometimes this gets very challenging when we have challenging beneficiaries, and that's a subject that hopefully we'll talk about a little bit here if time allows. As I mentioned, we want to have checklists. We want to be paying attention to our critical dates, and organization is a key. So we want to pay attention to the date of death, of course, and of course a death certificate is issued. There are letters of administration in probate. So this checklist here, and I want you to refer, if you would, to your checklist that says critical dates, and you'll see the word estate, E-S-T-A-T-E, estate of, and you'll see personal representative. And for those of you who are not familiar with this, in many states, the personal representative is called the executor, the person who is going to be in charge of the estate. In Maryland, we call that the personal representative. So in a probate estate, the petition for probate is going to be filed, and that's going to either be a small estate petition where the estate is under $50,000 or $100,000, depending on the circumstances, or it's going to be a regular estate. So letters of administration are issued. Those are the official letters. They have a raised seal, and that gives the personal representative the authority to marshal the assets of the estate. And why is that important? Because we have an inventory due within 3 months. So from 3 months from the time the estate is opened, we have to provide the Register of Wills with appraisals and actual values of the date of death values. Now, there is something called an alternate valuation date, and we won't spend too much time on that, but you need to be aware that there is such a thing, that assets can be valued in an alternative way 6 months after the date of death. You need to be aware that claims may be made against an estate within 6 months of the date of death, not 6 months from the time the estate is open. So that 6 months starts running from the time of the decedent's death, and we need to understand that claims can be made, and they are official verified claims that the Register of Wills will make note of. And if you're a personal representative, you need to be aware of this. Spouses can make elections against the estate, and we need to be aware of the new augmented estate, or what I will call the new spousal elective share of that came into law in October of 2020. We want to be aware of this law just in case we have situations where spouses are not leaving 100% to each other. The new law says that spouses, in essence, are able to obtain at least 1/3, roughly, of all assets. So the new augmented estate, or the new spousal elective share, allows a surviving spouse the assurance that he or she is entitled to at least 1/3 of all assets, basically. Now, don't take that too literally, because it's formulaic and the new law is a little bit complex, But I just want you as a fiduciary to understand that there is a new spousal elective share law. It affects estate administration and wills and trusts, but it also affects elder care planning because the state of Maryland has taken a favorable position about a couple that's positioning assets for long-term care purposes. That's beyond the scope of our discussion today, but just know this law is very complicated in some ways, and it's very good in some ways to protect spouses and also to protect spouses in situations where there is a long-term care situation. Disclaimers, which means I am giving up the assets that I just received, those things have to be done within 9 months if it's going to be a qualified disclaimer. Now, disclaimers can be made for Maryland purposes at any time after someone passes away, but this is something we're calling a qualified disclaimer, and those are due within 9 months or have to be done within 9 months. The federal and state estate tax return has to be done within 9 months, or there has to be an extension. These are critical dates that you need to be aware of. The QTIP election, meaning the qualified terminal interest property election, or what we would call the marital trust election, has to be made within 15 months. I strongly suggest that you not wait 15 months to do that, but sometimes it would be prudent, but most of the time, in my opinion, it wouldn't be. The portability election, which is the ability of the survivor to port the deceased spouse's exemption amount, the unused exemption amount. President Biden and Senator Sanders and Senator Van Hollen in Congress don't seem to be that interested in changing the portability election. So that's a very good thing for clients. That portability doesn't seem to be going anywhere. That's the ability to use both exemption amounts in a spousal situation. And that election has to be made within 24 months, which is very liberal on the part of the IRS. The good news is the QTIP election and the portability election get made on the same form, 706. And to me, in most cases, this is a no-brainer, especially with portability, that a surviving spouse would port the deceased spouse's exemption amount. And of course, we're getting ready to enter into an era where the exemption amounts are supposedly going to be lowered. So portability is very important and probably will remain important for many years to come. In an estate administration, the first administration account is due within 9 months. Subsequent accounts can be due, but it does not have to be closed within 9 months. And we'll talk about that on a case-by-case basis. Now, personal representatives or trustees, but in this case, personal representatives, have the right to be released from liability. I would argue that the final order of the court, which authorizes the personal representative to make distributions, that basically is a release from liability, in the sense that you have the authority to make distributions. Some personal representatives will seek a further release of liability, and that's going to be on a case-by-case basis. But definitely as a trustee, you are entitled to be released from liability, and hopefully all the beneficiaries, and they usually do, all the beneficiaries would sign a release of liability. Retirement plan accounts have their own life, and they are a separate animal, as many of you know. So we need to just know, and we don't have time to get into the entirety of this today, but you need to know that retirement plans need to have action taken for the claim of those retirement accounts and the separation of those accounts into separate IRAs and so forth. And there's a timeline that begins in September of the year following death. So September 30th of the year following death, the beneficiaries are finalized. They must become final, and that is something that's beyond the scope of our discussion today. By October 31st of the year following death, the documents have to be provided to the custodian. And by December 31st of the year following death, the IRA has to be separated into separate shares. So these are timelines that are critical. There are also critical timelines about people who are subject to inheritance tax, people who are subject to the 10% inheritance tax, which mainly applies to non-lineal descendants like nieces and nephews and friends and so forth. When we take control of retirement plan assets, or when the retirement plan assets are death claimed, then the inheritance tax is due on that retirement plan. And you as a fiduciary need to be aware of that, because when that retirement plan is claimed and the inheritance tax is due, that might be a date and time that is much different than the final administration of the estate, and the inheritance tax would be due just because the retirement plan was claimed and not at the end of the administration. So you have to be very careful about that. You also have to be cognizant of the Secure Act, and as you try to help the beneficiaries obtain control over their IRAs, or if as you try to set up inherited IRAs into further trusts as a fiduciary, you need to be aware of whether or not there will be a 10-year rule under the Secure Act, or whether minimum distributions are going to be allowed throughout the lifetime of the beneficiary, based on the fact that maybe the beneficiary is exempt from the Secure Act. And there are 5 categories of exemption, which we won't have time to get into today, but that is something that you could basically brush up on, and Jeff can send you a link to our presentation on the Secure Act. We did one that was very comprehensive about a month and a half or 2 months ago. So you need to be aware as a fiduciary of the ramifications of the Secure Act. Then there are estate tax returns, and these are Form 1041s. The fiduciary estate tax return for income tax, we need to be aware of that. And we need to be aware of the decedent's final income tax returns. We need to be aware of a closing letter from the IRS if there are tax issues, and so forth. Jeff, I'm going to stop before we get into the next segment and just see if there's any questions.
Thanks, Steve. No questions as of yet. So
Excellent.
everybody,
Okay.
please feel free to get those questions in. I know there's some out there.
All right. Thank you, Jeff. Now, I'm going to promise to plow through this and get to the examples, which I know many of you are waiting for, in the non-probate administration. So now we're talking about the administration, let's just say for our purposes today, the administration of a revocable trust. I'm not going to go through every single one of these, but you're going to see that many of these are the same. The date of death values are important. Notice to beneficiaries. So ever since 2014, in a trust situation, Maryland now has adopted something called the Maryland Trust Act. So beneficiaries prior to 2014 really did not have any really clear defined rights. And now we know that beneficiaries, qualified beneficiaries, are entitled to information, and they are entitled to a copy of the trust, and the trustee must give them this information. Generally speaking, the trustee must notify qualified beneficiaries. Notice to creditors. Many of you are not aware that a revocable trust can give notice to creditors and basically foreclose a creditor's claim if the creditor does not make a claim within 6 months. So the state of Maryland provides a template for a notice to creditors, and I think as a best practice, fiduciaries would give notice to creditors every time, and we advise clients to do this, even if it appears that there are no obvious creditors. Now, honestly, I have never seen a creditor make a claim against a revocable trust, but it is possible under the law, and I think this is a best practice. The spousal elective share, this slide needs to be changed, Jeff, actually, because that has now been approved in Maryland, as we talked about in the last slide, as of October of 2020. As of October 2020, we actually do have an augmented estate. So if you're making notes, make sure you scratch this out. We do have an augmented estate, and that is the new spousal elective share that I described a few minutes ago. The Q-tip election and the portability election, that remains the same, even though this is a retirement, a non-probate plan, a revocable trust plan. Disclaimers, the same timeline. Federal and state estate tax returns. Retirement plan accounts, the same situation is the case, except that in the case of a revocable trust, if a retirement asset is left into a revocable trust, if the revocable trust is actually the beneficiary of a retirement plan, which many times here at Elville and Associates, we do not take that approach, but many estate planning attorneys will take that approach. And remember, the analysis there is whether the revocable trust is a see-through trust for purposes of the IRA going straight through that revocable trust down to the beneficiaries. So that's why you need to be aware of how retirement plans work with regard to estate planning, and you need to be aware of the ramifications of the Secure Act. So for those of you, again, who are interested in this particular subject, the #1 expert, as far as I'm concerned, in the country, her name is Natalie Choate, C-H-O-A-T-E, Choate, Natalie Choate, and she has a book that you're certainly able to buy, and I believe it's called Life and Death Planning for Retirement Plans in Estate Planning. So that Life and Death book, which you can easily Google, is a tremendous resource if you're really trying to make yourself educated and aware of this. And as I mentioned, our Secure Act presentation, which I believe was very comprehensive about 2 months ago, I highly recommend that you look at that. We talked about in a non-probate situation being able to get a release and a waiver or even an agreement about refunding assets if there was still any kind of liability to the trustee. You're absolutely able to do that in most circumstances, and we strongly recommend that before you distribute trust assets that you get a release, waiver, and refunding agreement signed by all beneficiaries, and that you refrain from distributing assets in a trust until you've attained this, because what we're trying to do is, in best practices, is also protect you prior to a distribution. Okay, so I've gone through in pretty quick fashion the legal process and what are, some of the normal things that you're going to be facing as a fiduciary in reference to these checklists, as I tried to explain them on the PowerPoint slide in very, very quick fashion, which I apologize. And now, with your permission, I'm going to go backwards and I'm going to go back up to those 4 fact patterns. And we're going to walk through these with a little bit more detail. I'll give you my personal impressions and thoughts, but these by no means are exclusive thoughts or ideas. I want you to always know that estate administration and trust administration is fluid. Every situation is different. Every family is different. Every need is different. And of course, some things are constant, like our checklist. Some things are constant, relatively speaking, like the IRS code and regulations and so forth, even though they change. But we just need to remain flexible and aware. But we want to be driven by a process. So let's just get into this now. I want you to reference your estate checklist, not your trust checklist. And let's take a look at this.
So Steve,
yes, Jeff.
Before we delve into this piece, we do have one question. Do you mind if I ask that to you right now?
Go right ahead.
Thank you so much. So the question is, if someone dies with all assets in a trust, i.e. no probate assets, this was a second to die spouse, so no portability election is needed. Also, the estate is below the limit to file an estate tax return. Is there anything to file other than the last income tax return?
Thank you for that question. And of course, this can't be legal advice because I don't know all the specifics of the trust or estate that you're talking about. I think it's a trust. But generally speaking, just the first thing that came to mind when you asked that question, and I thank you for that, is that you would need to make sure you filed the fiduciary tax return, meaning the income tax return for the trust itself after the death of the person, and this is called the 1041. So what I kind of immediately gravitated to mentally is that I didn't hear you say the 1041 had been filed, so I think that is the first thing. It's not exclusive because I don't know all the circumstances and would have to meet with you in person to advise a little bit more comprehensively. But my first thought is I didn't hear you mention the fiduciary tax return. So the 1041, Uncle Sam wants to know who's going to pay the tax from the time of death until the time of distribution. So that's what I would consult with a CPA or an attorney about, is that 1041.
Okay, thank you very much.
Thank you, Jeff. All right, let's get into this first fact pattern. Felix was a single person. He was never married. He was a bachelor for his entire life. Yet he had a child, and he was age 77 when he died. And we have no information here that Charles has any issues. He's probably an older son, at least in his 50s, I would imagine. Don't know. And Felix died with a will, and his will is very simple. Everything goes to Charles outright. So Charles is going to have to open the estate. As we look at this checklist, he is going to have to obtain an EIN for the estate. He's going to obtain date of death values, because after he opened the estate, he gets a letter of administration with that raised seal, and that allows him to do several things. He gets to sell the house, which he probably will do, or he could distribute the house to himself in kind. He does not have to sell it, but most of the time he would sell the house. He's going to take control of the checking, savings, and CD accounts, which are in the name of Felix. These do not have beneficiaries. In my example, they are in the estate. And so he's going to take that money and he's going to put that into an estate account. He's probably going to go to his local bank with the tax ID number and he's going to open that estate account. And now he's going to use that account kind of as the center of the universe, so to speak, for the estate. So if Felix gets a tax refund, if Felix gets a refund from an insurance premium, he's going to put that into the estate checking. If if Charles had to pay the final expenses and now he's entitled to reimbursement, he's going to write himself a check out of estate checking. So basically, he's going to pay for professional fees, he's going to pay for tax preparation, all of those things out of the estate checking, and he's going to include that in his accounting. The IRAs, I'm making the big assumption that these were left to Charles by beneficiary designation. So Charles is going to make a death claim. There is no inheritance tax because Charles is a lineal descendant. So Charles is just going to make a death claim. Now, many beneficiaries think, well, Steve, I just want to get my IRA, just get me my IRA money. Well, that's not how it works. For those of you who have seen this or done this before, you know that the beneficiary has to contact and set up their own IRA at the custodian. Now, of course, they could make a trustee to trustee transfer and change the custodian, but basically they're setting up their IRA. And what's going to happen here is Charles is going to set up his IRA. That's an inherited IRA. And what do we know about inherited IRAs? Well, under the Secure Act, if Charles was a survivor and Felix had died after January 2020, we have no indication that Charles has any disabilities. Charles is going to have 10 years to take the entire amount out of that IRA. And of course, we have no indication that this is a Roth IRA. So let's say this is a traditional IRA. Charles has to pay all tax on that IRA within 10 years. In other words, at the end of 10 years, the entire IRA has to be empty. So he sets up his IRA and he can either cash the whole thing out or he can take it for over 10 years. There are no minimum distributions. Now, the savings bonds, these are unique, and many of you have seen this. Many of you have savings bonds. The savings bonds are what we call income in respect to a decedent, income with respect to a decedent. In other words, the income tax on the savings bonds has not been paid yet, just like the income tax has not been paid yet on the IRA here that Charles is setting up, because it's not a Roth. So what has to happen here? Well, Charles is going to take control of these. He's going to just probably cash them out. And I don't know what else he could do with them. And they will actually be a part of the estate. There's no indication here that the savings bonds were transferable on death to him, which is a possibility, or POD. There's no indication that he was a joint owner with his father. So now he will take receipt of $350,000. And the question is, who's going to pay the income tax? So the CPA or attorney involved is going to advise about this. And it's either going to be income tax on Felix's final tax return, or it's going to be income tax on Charles's tax return because he took income of $350,000, ordinary income, or it's going to be on the estate tax return, meaning the income tax return I just mentioned a few minutes ago, the 1041. So this is going to be either on one of those tax returns or a combination of all three to try to minimize the income tax that's going to be due on this savings bond gift. So there are no lifetime gifts. Felix never made any gifts. So at his death, it looks like Felix would have had an $11.7 million exemption from estate tax on the federal level and a $5 million exemption from estate tax at this date and time for the state of Maryland. So there's no indication that he lives anywhere else except Maryland. And also he had no creditors. So when this estate was opened, Charles cooperated with the Register of Wills. The Register of Wills published notice in the newspaper, which many of you see, or online nowadays, and that is the notice to creditors that they have how many months? 6 months from the date of death to make a claim, and there has been no claim in this example, no creditors. So Charles will be able to pretty much close the estate out fairly soon. He may not have to wait the entire 9 months, and he is an only child. So this should be a pretty straightforward administration. The Social Security Administration is usually notified by the cremation service or funeral home, as many of you know. So this one is pretty straightforward. And if you're a personal representative of this kind of estate, you know that you're going to open the estate and close the estate, and you should probably make no distributions until there's a final court order. Remember, on your checklist, we are talking about 9 months is when the first administration account is due, unless this is a modified estate where no accounting is due. And let's say an accounting was normally due. Let's just say that this particular case, there would be an accounting. The Register of Wills approves the account, and then there's 20 days for exceptions or objections. So in this case, there's really no one to object. So the court would approve the accounting if an accounting was done here, and then Charles would take control of the money. So very straightforward. That's our hypotheticals fact pattern number 1. What I encourage you to do is take these facts, take my comments, go down the estate checklist, and just see which one of these checklist items really applies to this estate as I've described it. But hopefully that is a good illustration of a person who died with a will and there is a probate process. Now the second fact pattern, as I check my time, and I'll make sure that we continue to move quickly. This is the fact pattern where there is a death of a first spouse, Jack, who died at 69. He has a revocable trust. And as we have said before, this revocable trust is fully funded, and Janet is the surviving spouse. And we know that the revocable trust leaves everything outright to Janet. And what does that really mean? That means that Janet basically will have everything in her continuing revocable trust. She will continue to have a revocable trust throughout the rest of her life, as we'll see in the next example. And we're making the assumption that the residence and the CDs and all the non-retirement assets are in the trust. We don't have any indication that the children have any issues. So if this is an outright distribution to Janet, then basically we are starting from the beginning. We want to make sure we have date of death values. Why do we want to make sure, if we're a fiduciary, if we're a trustee of this trust, why do we want to make sure we're covering all of our bases? Well, because we have 3 children, not only because we want to do best practices and we're professionals, or we're non-professional fiduciaries that are going to do a wonderful job, but we have 3 children to account to. So we are going to have to account for everything from the date of death until the time of distribution. Now, what makes this a little bit easier? Well, what makes this easier is everything so far is pretty straightforward. Everything is going outright to Janet. She's the surviving spouse. And so this administration would be fairly limited, actually, because we have a surviving spouse. Jack's trust, or Jack's portion of his joint revocable trust, if it was a joint trust, that becomes irrevocable and that has to be distributed. But this should be relatively straightforward. Okay, so let's go through this. The residence, let's pretend it was a joint trust. That residence passes to Janet. The checking and savings, which was jointly owned inside of this joint trust, passes to Janet's side, and now that will continue in her revocable trust. Jumping down to the brokerage account, that brokerage account, which was in essence jointly owned in that joint revocable trust, or if it was separately owned 50-50 in separate trust, it now passes to Janet and will continue on basically in her trust. The Delaware residence would be the same as the Maryland residence. It would continue on in the trust for Janet, outright distribution. Now, what would have happened if you look down at the bottom here? What would have happened if this was not an outright distribution to Janet? What if this was a formula clause? What if this is an old trust, like many of you may have seen, where it says at the death of the first spouse, there will be a family trust or a bypass trust or a credit shelter trust, meaning a trust that is funded with the maximum amount allowed by federal law and the maximum amount allowed by state law. So these are the considerations, because if there's a formula clause, then there is no outright distribution to Janet, and instead a bypass trust, which is a term of art that is created for her benefit in that example. So we don't have time to get into that today, but it could be outright to her, it could be a formula clause. But let's just continue with the assumption that this is an outright distribution. So now if we add up all of these assets, we see that Janet is under the federal threshold and so forth. So we don't need to disclaim any assets. And what do we want Janet to make sure she does? We want to make sure Janet does something called making the portability election. So we want to make sure that we're guiding her to choose to port Jack's 11 million for federal, his 11.7 million that he never used, because we see there were no lifetime gifts. And we also want him to port his Maryland exemption, which Maryland has portability. And now what does Janet have? She has 23 million plus of exemption, plus she has 10 million of exemption for Maryland, at least until such time as the federal government changes its exemptions with regard to Janet, the survivor, or Maryland changes the amount of her exemption. So in essence, she has locked in Jack's portion of the exemptions, and she has done exactly, in my opinion, what she should do. Now, is that a cheap thing to do? No. Filing the Form 706 is very expensive, but to me, it is kind of a no-brainer. It is an heirloom that Janet is giving to the family. Let's go back to the 401ks and IRAs. So those are going to be beneficiary designated to Janet in my example. She's going to make a death claim on those assets, and she's going to roll those over to her own IRA, most likely. So that is basically this example. It's relatively straightforward. What do we have to make sure of? We have to make sure that if there's any 1041 due, then we have to make sure the 1041 is done. Taxes that were due after Jack's death until the time of distribution. We have to make sure that's covered. We have to make sure the portability election is covered. We have to make sure Janet is healthy and well and doing well and has the support of her children. But basically, in a nutshell, that is a spousal situation at the time of the first death with a revocable trust. And again, I would encourage you to take this trust checklist, but also as you're analyzing this with these critical dates, remember that this is a fairly straightforward situation because we have only the death of the first spouse. Now we have a more in-depth situation where I want you to refer to that same trust checklist. Janet has now survived 20 years and her assets are a little bit different. She now lives in a continuing care retirement community. Her IRA assets have grown a little bit. Her brokerage account has grown. Now, maybe over 20 years, these assets would grow much larger than this. So for you financial advisors on the line, just know that I was basically making this up arbitrarily. She is now a Florida resident instead of Delaware. She got tired of the slower, lower state and went to really a lower state because she loves the warmer weather. There are no lifetime gifts. However, there are several creditors. Janet, for example, may have taken up some hobbies that she shouldn't have. Maybe she has a lot of credit cards. Anyway, I'm making up this scenario, as you know. So here we go. And also notice that one of the children is disabled now. One of the children, heaven forbid, has a dramatic situation or traumatic brain injury, I should say, and now is a special needs person. But that was never addressed in the documents, never addressed. So let's go through this checklist. At the death of Janet now, the fiduciary is going to have to account to all three children. And as we go down the checklist, we have to have date of death values. We know there are creditors, so we're going to run notice to creditors. If the creditors do not make a claim against the trust, the fiduciary does not have to pay those claims. Now, sometimes a fiduciary will say, well, Janet would have wanted those claims to be paid, so I'm still going to pay it anyway. But know legally that unless there's a valid claim made against the trust, and unless it was some practical thing like a utility bill or something, those medical bills, those gambling bills, those credit card bills would not be paid legally unless there was a claim. The deposit at the continuing care retirement community. The retirement community is going to typically re-let this space that Janet was living in. It depends on the contract with the facility. It depends on what type of CCRC that is. But let's pretend that Janet's trust is entitled to a certain refund of the deposit. So hopefully she designated her trust as the beneficiary, or maybe she beneficiary designated the children, or maybe she beneficiary designated her estate. But let's just assume that she did it properly and she designated the trust. So that 350,000 or the remaining amount that's supposed to come back is going to come back to the trust. And that may not happen for several months. So we may be holding this trust open until we would be holding it open until we receive the CCRC refund. Checking, savings, and CDs. Remember that at the time this trust is opened and creditors are notified, as a best practice, we're going to get a tax ID number for this trust unless there's an estate. So let's just assume there's nothing in the estate. Let's assume that everything was properly funded. We're going to get a tax ID number for this trust. The trustee is going to open up a trust checking account, and that's going to be the center of the universe for the trust, just like the estate account was, to have the cash in there. So the checking, savings, and CDs are going to be put into the trust checking account. I'm going to skip the IRA for just a second. The brokerage account, the trustee is going to have to decide, do I sell all the assets and get a step up in basis? Okay, there's no capital gain. I have taken the assets out of the market. That's a tough call these days because the market has been doing so well for so long. But remember, as a fiduciary, you're going to ask yourself, what kind of risk do I have if I hold on to these assets? What if the assets dropped 40% in the market? What kind of liability would I have? So a good best practice might be to sell those assets, but that has to be a thought process. It has to be something that you're thinking through. So those brokerage assets are going to be in the name of the trust now, the administrative trust. At the time of Janet's death, her revocable trust, just like Jack's, becomes an irrevocable trust, and it has to be administered. And the trustee is going to start an accounting, is going to account for all income that's coming in, all expenses, including final expenses that are going out. All of those things are going to be accounted for. Life insurance, Janet had life insurance, and that is beneficiary designated. So let's assume that came into the revocable trust. The trustee is going to make a death claim on that if it was the trust as the beneficiary. The Florida residence is either going to be sold or it's going to be distributed in kind to the children. Let's pretend it was sold. Now what has to happen is the accounting is going to show all the realty fees, all the transfer tax, everything is going to be reflected on the accounting. There should have been a cost basis adjustment at death, so there's no capital gain, hopefully. And Uncle Sam hasn't taken that away yet. So as trustees and executors, we need to know that the elimination of the step up in basis doesn't seem to be on the table right now. Janet's income was $2,000 a month at Social Security, and hopefully the funeral home notified Social Security. Now let's get to the bottom bullet point in the interest of time. And let's look at this. The revocable trust left everything to the children equally and left it in further trust. Now, why would Janet do that? Well, she would have probably done that to give her children asset protection, protection from divorcing spouses, protection from bankruptcy, protection from car accidents and tort creditors, those kinds of things. Remember, those trusts do not protect alimony claims or child support, and they don't protect a child that has tax liability, but they protect very well for most other creditors. So those are things that are important to communicate with the children to set up those. Those trusts are irrevocable trusts at death, and they have to have EIN numbers of their own. So this process is very similar to the process of probate that I described in the first illustration, where we're administering the trust, we're marching through all of the processes. We're making sure we're doing the 1041 from the date of death until the time of distribution. And now at the time of distribution, we have to be aware that all these assets are going to be distributed in further trust. Let's go back to the IRAs. The IRAs are basically beneficiary designated in this example to the trust. So we have to work with the custodians to make sure that the further trusts are actually the owners of the inherited IRAs for each child. And here we see that most of the children, the two children, are still healthy. So they're going to be subject to the Secure Act. And that means that they have to take their IRA distributions in 10 years. But what do we see here in this fact pattern? We now have a child who is disabled. Now, hopefully in Janet's trust, her trust has a modern provision that says, hopefully, that it's a standby supplemental needs trust. So this is one of those examples where if we needed that standby provision that says that this child can have a special needs trust established for him or her, that the trustee can make that discretionary decision. So that is a best of all worlds kind of scenario. There was a further trust for this child's health, education, maintenance, and support, let's say, but now because of the standby provision, a supplemental needs trust can be created. So hopefully that provision is in the trust. If it isn't, let's say this was an old trust that didn't have any of those modern provisions, then a decanting might be needed. This child is supposed to receive this share, but it could actually be changed under the decanting laws, let's say, for example, of Delaware or Virginia or Nevada, and actually changed from a maintenance and support trust to a supplemental needs trust. So these are some of the considerations just on the surface that you as a trustee want to be covering in your fiduciary role. As you get ready to distribute the assets, which might be quite some time given all these circumstances, it wouldn't necessarily happen quickly. And by the way, Janet had made the portability election, so hopefully there's no estate tax here, and you're cognizant of that. You get down to the final distribution, you have all of your estate accounted for, your trust estate, from the date of death until the time of distribution. All creditors have been dealt with in one way or the other. The IRAs have been claimed. The trustee commissions, the professional fees, everything is on the accounting, and now you're going to make your final distribution. But what are you going to do before you do that? You're going to get releases of liability signed and refunding agreements and so forth with all of the children before you make this distribution. So that's a very general example of how you would work through this fact pattern. And in the interest of time, we're going to go to the next one now, which is going to be much simpler. This is a death of a spouse who is still married. He is separated and has 2 children. And at the time of his death, his wife lives in New Mexico in a very different kind of situation. And I've actually seen this, not in this particular state that we're talking about here, but in another state. And this person has 2 children. One of the children is not in a good situation financially. So let's look at this. There is no estate plan. There's no will. There's no trust. Let's just talk about what would happen here. So this person has $3,100 in checking and savings. I'm going to skip over the IRA for a moment. He has an automobile. He has $177,000 of savings bonds. He has made lifetime gifts. So he has given away money. And so let's just go through this. The checking and savings is in probate. Why? Well, it had no joint owner and no beneficiary, and there was no will. But even though there's no will, the laws of intestacy are going to control. But there is still probate because this is a probate asset. The automobile is a probate asset. It was in his own name with no beneficiary. The life insurance is actually in probate because even though it's life insurance, it had no beneficiary. The savings bonds, as we know, are in probate, and we have the same issue. Who is going to pay the tax? Is it the children? Is it the estate, meaning the 1041, or is it the last tax return of the decedent? The lifetime gifts don't matter. He gave away $500,000. But during his lifetime, recently when he did that, how much estate tax or gift tax exemption did he have? He had 11.7 million. So he had plenty of exemption to give away that $500,000, which we assume was in cash. The other thing is that Maryland has no gift tax. So this really, if it was just cash, this is not going to make any difference for Maryland purposes. So that is the long and short of that. There will be an estate that has to be opened. A tax ID number has to be opened, has to be obtained, and an estate checking account has to be obtained. So now we are back to this critical checklist for estates, not trusts. But the only difference here is we don't have a will. So when it comes down to the distribution, when it comes time to make the final accounting to the Register of Wills and make the distribution, what do we know? We know the distribution is going to be driven by the laws of intestacy. And here, basically, the spouse, because they're still married, the spouse is going to get a certain percentage. I will have to set and look at this with the code, but it's approximately 50% The spouse may get the first 40,000 and then the balance, but the children are going to get a certain amount and the spouse will get a certain amount. So this is the law of intestacy that we're talking about here, and you have to be driven by that, which is in Article 3 of the Estates and Trust Code. As we get back to the inherited IRA, the children are going to receive the inherited IRA in my example here. I don't think in my example we would say that the decedent left this to his spouse. They were separated, so let's just assume that this was left to the children. The children would set up their inherited IRA. There's no indication that the children are unhealthy, so they probably only have 10 years to take this out under the Secure Act, so remember that. If he had left this, if the decedent had left this to his spouse, she would have the right to roll this over to her own IRA, and there is no inheritance tax in this example. They are still married, so there's no inheritance tax between the spouses, and there's no inheritance tax to the children who are lineal descendants. Last thing I'll say here is one of the children is in bankruptcy, so what we might be very cautious of here is what's going to happen to this child's share. There's probably nothing that can be done, in my opinion, because there is no will, there is no trust for this child. Everything just gets distributed outright. So unfortunately, this child may lose the majority of their share, and they have no asset protection in the inherited IRA. So the inherited IRA to the one child will probably have to go to their bankruptcy estate. All right, Jeff, we're going to now plow through the end of the presentation. I apologize for the time factor that we only have a few minutes left. So I'm going to go now through the practical steps. I've gone through the legal steps. I've gone through the examples. Now I want to finish up with the practical steps, and I thank you for your patience on this beautiful morning as we've gone through some very dense information. We want to schedule a meeting with surviving spouses or others within 30 days. Again, I don't think this is a hugely hurried situation in most cases. Sometimes it is. Many times there's 10 rental properties or 30 rental properties. There are pipes bursting and there are issues that have to be addressed. But generally speaking, in the normal course of events, we don't want to hurry too much. Within the first 2 or 3 weeks is fine. Certainly within the first 30 days, but not in the first several days after someone passes away. We want to coordinate with advisors and attend meetings. We want to use checklists. Again, I'm being redundant intentionally. We want to have organization. We want to have an inclusive process. There are beneficiaries that don't always get along, as you know, and some of you are laughing right now, and that's okay. But we want to try to be as inclusive as possible, and where we have danger zones or red flags with beneficiaries that are clearly going to cause a lot of problems for you and the estate, we want to be thinking carefully about that and getting legal counsel involved most likely to try to make sure that we're meeting our responsibilities. We don't want to be removed for failure to carry out our responsibilities, and that would cause lots of hurt and heartache and embarrassment. But we also want to make sure we're not, we're holding the line sometimes against unreasonable people who will be out there, and they cause a lot of liability for you as a fiduciary. Again, we want to exercise due diligence and take care of surviving spouses and others, provide support, be cognizant of resources. We want to encourage the surviving spouse in every way in these kinds of situations. And they are going to be driven many times to want to do their own planning. If they haven't done their planning, they're going to want to do it. They're going to want to update their planning, but we want to make sure that they're not trying to do that at their own detriment, meaning forcing themselves to do something when they are still suffering and going through the grief process. Organizational and general readiness, those are the key words. Traditional document storage and paper records, we want to think about those things in advance. If we have savings bonds that we've had in a safe deposit box and we have a stack this big, maybe it's time to get those electronically filed with the Treasury Direct. We want to think about digital assets. We want to think about archives. If a person has a digital archive in this day and time is a big question, we want to make sure we have passwords. We want to make sure we have access. So safe deposit box, do we have keys to that? And is it accessible? If there's a safe in the house, is it accessible? Now, what are the most significant things? Titling of assets prior to death. Many of you are very aware of this. This is part of the organizational and readiness process. The valuation of all assets after death. This is not only knowing what the assets are, but getting them valued. Caution in the retitling of assets. This is something that we see a lot. I see this more so than ever today, especially with our financial advisor colleagues. Many of you are providing such a high level of client service to your clients, and you're so involved with every aspect of their lives, which we really admire from the legal side. But we want to be cautious about the immediate retitling of assets on the death of someone. We want to be cognizant that that person who died, they have an estate plan, let's say, they have a document that is driving the estate planning, and that document drives how the account should be retitled, along with the tax process and the other processes of administration, and not just automatically retitling the assets in the name of a surviving spouse or child. That can be detrimental and actually contrary to what the decedent wanted. We want to make sure we're cognizant of inheritance tax issues, as I mentioned briefly, the portability election, the marital trust election, which is the Q-tip election. We want to make sure we don't miss those dates and that kind of tax consideration. And we don't want to miss foreclosing creditors. If we can foreclose the claims of creditors, even though it may seem like the decedent had no creditors, that's still a best practice. We want to communicate among the entire team. We want to know who's going to quarterback that team. For the advisors on the call, this is a very big issue. We want to have best practices. We want to be the highest and best communicators, but many times we don't do that well, and we want to work with the fiduciary to do that. And we want to come together as a team. We want to invest significant time during the decedent's lifetime to make sure all these things are done. Even if it's not you personally, if you know that you are in line to be a fiduciary for someone else, try to do the very best you can to make your life easier in the future. And I know some of you do that, and also to make sure that everything is done just so you'll be able to execute it more viably. If there is an illness, I would strongly encourage you to understand that many people who are ill and are doing planning, they tend to pass away sooner than we think. This has been my experience over the last 20 some years, sadly so. So if we are dealing with someone who has an obvious illness, we want to expedite meetings, planning, signings, accomplishing objectives much quicker. And that goes without saying. We want to ascertain the client's wishes, and we want to encourage them to use a memorandum of intent. Again, organizational tools, I'm being redundant. Education of family members and fiduciaries. This is very important. We want to have a method of reporting to all advisors, meaning not only the quarterback, but the dissemination of information quickly. And we want to ensure and instill confidence in the client and in the entire family that things are in order. So I thank you for your patience as we're running right up against an hour and a half for this presentation. So one of the things that we are committed to at Elville and Associates, if I could just say this for a second, as far as being a practical help to you, we are educational. We are committed to education. We are committed to education of family members and fiduciaries. But we also want to make sure that we're not just educating, but that we're actually giving you a path forward. So we want to be here for you as fiduciaries, as advisors. We want to be here for your children. We want to be here for your clients and the people that are going to need you and us down the road. Any competent lawyer can advise you at the time that you are acting as a fiduciary, but obviously we want to be here for you. We want to be your advisors, and we want to encourage you to come consult with us. There is nothing to fear. There is no charge to consult. We want to see current estate planning documents, either for yourself or for the person that you will act as a fiduciary for, if it's that kind of relationship. We want you to have those organizational tools in advance. We want to have an advisory team, and if you don't have one, we want to help you form one. We have many relationships, and at least one of our relationships would probably be a good fit for you as a person or as a fiduciary. We want you to come with questions that you may have, and we want to give you time to think. So with that said, I want to make sure we end on time and entertain any questions. I know we're running a little bit over with our questions, maybe. Jeff, I'm going to turn it back to you, and it's still sun shining outside, and I hope everyone has a great weekend ahead.
Well, thank you very much, Steve. Very important subject and a lot to get in. I think that when we were doing these in person, we sometimes allotted a couple hours for this presentation. So a job well done as always. So I think we have a question or two. The first one being from our friend Diane, our CPA friend Diane, who you know. And I think we're going to want to go back to fact pattern 3, if you wouldn't mind jumping back to that for just a brief minute. And the question is, in fact pattern number 3 for special needs trust, and modern clause is not in the original trust, and she lived in Maryland, how can you decant the trust? Does Maryland allow decanting?
Diane, hi, first of all, and thank you for attending, and hello to everyone at Heimlance. I will just say Maryland at this point does not have decanting. Our neighbors, Delaware and Virginia, have pretty robust decanting, especially Virginia, I've seen recently, that's changed their decanting laws even more recently. So those are tools that I think we can use to decant Maryland trusts easily, where decanting would be allowed and appropriate. But Maryland does not have decanting now and may have it in the upcoming session. Maybe the estates and trust section of the bar will introduce a decanting law, but right now, to my knowledge, we do not have any decanting in Maryland. And when we do, it'll probably be fairly conservative. Virginia and Delaware, I think, are tools for decanting.
Okay, thank you. And next question is, what is a memorandum of intent?
Thank you. So a memorandum of intent is what is missing in many estate planning documents. I'd say the 95% of all estate planning documents. A memorandum of intent, or I'll use a different term of art, a letter of wishes, is something that can be attached to a will, it can be attached to a trust, and basically it's an informal description of the grantor or the testator, the person who's creating the will or trust, of their concerns, their ideas, their goals, their values, what they want for the beneficiary, instructions for the trustee. These are more informal instructions that have nothing to do with the trust terms. So in special needs planning, we might call this kind of thing a special needs memorandum of intent, which talks about the disabled person, their life, their interests, their doctors, their health condition, their loved ones, everything about them. And this is designed for a trustee to look at this in the future, that we may have an unknown person that's going to look at this 20 years down the road and they don't know the beneficiary. In non-special needs planning, we might be talking about a letter of wishes, which is really the same thing. It's something that's setting out your goals and values and your aspirations and what you wish to pass along, not only instructionally, but with your values. So anything goes with regard to these. And what we normally do is get your input. We type this up as a standard memorandum to the back of a will or trust. And we strongly encourage you to keep these things in Word format or some other word processing format so that it can be updated every 5 years or so. But by doing this, a memorandum of intent or letter of wishes, you are basically personalizing your will or trust in a way that 95% or more of other people do not do. That's what that is. Thank you for the question.
Thank you. And last question, which I might be able to answer somewhat. Very helpful information. Thank you. Important to be prepared for an initial consultation with both relevant documents and information, plus the level of support desired. Are there online forms at Elville that can be downloaded and filled out ahead of time? So I can probably answer a little bit of that. We do have our forms on our website at elvilleassociates.com. There is a drop-down tab that says forms that has our questionnaires on it. And so I'll preface it by saying now would be your time to get your last questions in, please. And in my post-webinar follow-up email that many of you know, I always try to send out with some good information and resources for you. I will send a link out with a link to that questionnaire. And I'll also send out the memorandum of intent that is helpful to you in many different situations that Steve just described. I'll also send out information about the Secure Act that Steve referenced. He wrote many good articles about the Secure Act over the last several months, along with the presentation that we recently did that was very good. And so I think those are all the bullet points that I wanted to touch on that I'll
Jeff,
be
if you
sending
don't mind
out.
me just jumping in real quick, if you would also
Yeah.
send out a letter of wishes for anyone that wants one, which
Okay.
is a little bit of a different approach to the memorandum of intent. And I also wanted to say in answer to that question that we do have a questionnaire for estate administration or trust administration also at the time that that might need to be used. So we do have an estate administration checklist, or not only just checklist, but a questionnaire. So not just an estate planning questionnaire. Thank you.
Okay, very good. Yes. And just briefly, since I know we're up against the clock here, for those interested, our next few webinars on November 3rd, Guardianship and the Alternatives, what parents and family members need to know on November 3rd. November 12th, the Essentials of Estate Planning and Elder Law. We always try to host that once a month. November 16th, Maryland Able is going to be coming back to talk about Able accounts and how they benefit your loved ones with special needs. And November 16th as well, later in the afternoon, part of our wellness series, which has become very popular, taking charge of your health journey. Really encourage you to take advantage of that. Very good presentation by Ms. Ellen Platt of the Option Group and Dr. Michelle Fritsch. So that is everything from us at Elville Associates today. Again, thank you, Steve, and thank you everybody for being here and for your questions. And hope you have a wonderful day, and we look forward to seeing you again soon.
Thank you, everyone.
Thank you very much.